And do federal agencies have too much power?
Well, there's a group challenging this in the Supreme Court, and they are winning. For example, the Supreme Court took up the case of an auditor in a small Texas accounting firm who was fined $22,000 after the SEC said she broke the rules. But the judge in the case was picked by the federal agency itself.
Sound fair? In 2023, the High Court ruled unanimously that people like that auditor can challenge the protections surrounding that judge before they determine rules were broken.
For more on further efforts to reduce government agencies' power, we hear from Peggy Little, a senior litigation counsel at the New Civil Liberties Alliance.
These agencies, they pass the rules, they charge people with violations of the rules, they adjudicate the rules, they issue the penalties for the rules, and they are the first court of appeals for that prosecution. Any time you have that concentration of power in one branch of government, the founders described that as the very definition of tyranny. So we were delighted to receive a unanimous ruling overturning 6 circuit courts of appeals that said, no, you may go to a real U.S. district court and challenge whether those proceedings are constitutional.
Right, Peggy, and your founder of your organization calls this administrative absolutism, and he says it's not new. It goes back to that power that the medieval kings wielded, and he's saying that the federal government agencies are now taking up this power when we know it's in fact Congress that enacts the laws of this land. So what about these pending litigations?
Yes, then we have 3 other cases that have been argued but not decided this term. One is the Cargill case. That was Richard Samp was our lead counsel on that matter, and Cargill is a deference case, and it is an important case because what happened is the Alcohol, Tobacco, and Firearms agency, this again is an agency, decided after the Las Vegas shooting that bump stocks were now illegal. But Congress never made that decision. And in fact, for decades, bump stocks had been legal. So the question in that case is, does Congress make the law, or does an agency's flip-flop become the law? So it's a very important case on the source of lawmaking power, and we were thrilled to see the U.S. Supreme Court take the case and look forward to its ruling.
Well, of course, and you had mentioned surrounding some of these victories here that there is a tide turning now in favor of those who want to pull back that power from the federal agencies here. So what is it looking like in the Supreme Court? How are they leaning?
Well, I think that the Supreme Court is concerned. Justice Gorsuch and Justice Thomas have long been concerned with this transfer of lawmaking power to administrative agencies. Deference, which is the issue in the cases Cargill and also in Relentless, is Chevron deference. In those cases, what you have is a court saying, well, the agency's view of the law prevails in an actual proceeding, and that can't be right. It has to be, when you go into court against an agency, it is the judge who needs to decide what is right. And when you have a rule like deference that says essentially the agency always wins, that transfers. It's an abdication of judicial power, and the judicial power is vested in a separate branch of government and should not ever be the case where the executive gets to be the winner in such proceedings. And then we also have a case of Murphy versus Missouri at the court.
Peggy Little, Senior Litigation Counsel at the New Civil Liberties Alliance, thank you for weighing in.
Thank you so much for having me.